Hi, this is Blaine Cluten for Cluten Law. A less frequently asked question, but a still interesting question, is whether parents or guardians are liable for the acts of their children. Historically, the general rule was that parents are not responsible for the acts of their children. However, the Oregon State Legislature, through a series of laws, has largely changed this general rule and enacted several laws that can make parents or guardians liable for the acts of their children that are under 18. The liability of the parent or guardian generally comes from the acts of the child or the negligence of the parent or guardian as it relates to acts of the child. So an example of this would be a parent or guardian can be held liable for negligently allowing their minor child to operate a vehicle if the act resulted in injury to another and the parent or guardian knew or should have known that the child was not a competent driver. Parents may also be held liable if a minor child fails to pay taxes on income they have earned. If the parents are not married and a parent who has custody of the child is the one financially responsible for any damages the child causes. So the next question is, what are parents or guardians specifically liable for? In Oregon, if the child is under 18, not married or emancipated, and commits an intentional or reckless act that damages property or injures someone, a custodial parent or guardian is usually legally responsible only for the actual damages caused by the acts of the child. This means that the injured party must show the out-of-pocket expenses incurred to repair the damage caused by the minor child, such as medical bills to treat the injury caused by the child. There's no limit to the custodial parent or guardian's liability if the minor child is responsible for damaging school district property, has stolen merchandise, or has taken agricultural produces. In these situations, the owner of the damaged or stolen property can recover the actual cost to repair or replacement of the property from the parent or guardian, and parents can also be held liable for a penalty of no less than $100 and no more than $250, in addition to the value of merchandise shoplifted or agricultural produce taken. So the fortunate part for the parents or the guardians is that in other situations in Oregon, the law does put a limitation on the amount for which the parent or guardian can be liable. Even if the person can prove actual damages occurred, the most he or she can recover from the parent or guardian in most cases is $7,500 or the amount of the actual damages, whichever is less. The $7,500 limit is per person making the claim, no matter how many separate acts the child committed during the incident that caused the injury. And for parents or guardians, they may be liable for up to $5,000 in fire suppression costs incurred in suppressing forest land fires caused by a minor child, and up to $5,000 awarded in a judgment against a minor child for damages including emotional distress in a civil action for intimidation. This has been a brief overview. This is Blaine Cluten for Cluten Law, talking about what parents and guardians can be liable for the acts of their children. If you have further questions, please contact a legal professional. Thank you.